A local Japanese couple lived in Manoa. They had their home, so they transferred the home into their son's name. He was married. He went to a local college and met a girl from out of the country. She was from Germany, and they got married. And they had a good relationship. There was no divorce. There was no problem there. And the son and his wife got into a terrible car accident. True story. They both died. But the son died first, and then the wife died. So what happened to the house? When the son died, he didn't have a will. Who was entitled to his assets? His wife. She got everything. For the few minutes or hours that she lived longer than him, she was entitled to her in-laws' house where they all lived together. And then she died shortly after that. When she died, she didn't have a husband. He was already dead. She didn't have kids. They didn't have children. Who would get it? Her parents. So her parents in Germany inherited this house in Hawaii. When they got the news from the lawyer that they'd inherited a house in Hawaii from their daughter, they said, we don't need the house in Hawaii. Let's sell it and take the money. Sold the house, and the local couple were homeless in their old age, and the German couple got the money. True story. But that's what can happen when you try to keep it simple. All these risk factors can come up, and that's the benefit of trusts to avoid that problem. That could have been avoided with more careful planning. I'm Ethan Okura, and I'm with Okura Associates estate planning attorneys. I didn't come up with the name. It was actually my father and his law practice that I ended up joining after law school. Grew up in Hilo on the Big Island, went to New York City for law school at Columbia University, and then after 3 years doing the grind for Wall Street law firms, came back to join my dad's practice and have been doing estate planning since 2005. We do all aspects of estate planning: wills, trusts, probate, some creditor protection, tax minimization as related to estate gift taxes, and some with capital gains as it relates to stepped up basis on death. So today I wanted to talk about estate planning as a general overview for people who may not have much background or knowledge on it. To the extent that you folks already know a lot of this stuff, we can also accelerate it and go past and get deeper as much as you want. And also with question and answer, we can hit whatever questions that you might have. What is estate planning? It's a process where we're trying to protect our assets. And what are we protecting them from? Typically, we're looking at protecting our assets from probate, estate taxes, conservatorship and guardianship, and nursing home costs. And also creditors. It's another big one that a lot of lawyers just ignore. So how do we go about this? There's generally 4 main documents in estate planning that are the base that pretty much everyone should have. Typically, we want to have an advanced healthcare directives and or HIPAA authorization. And the idea here is, what if I become mentally incapacitated? That's one of the first questions. If I'm in a coma, or I've had an accident, or I got dementia, and I can't talk to my doctors and make my medical decisions anymore, then what? The advanced healthcare directives under Hawaii state law has 2 components. One is an aspect where you can appoint an agent to make medical decisions for you, and the other is you can choose your end-of-life decisions. If you're in some terminal situation, maybe you're in a coma, maybe you have cancer, maybe you have something that's incurable, irreversible, and there's no end in sight. Would you want life-sustaining treatment, life support? Would you want artificial nutrition and hydration, tube feeding or something like that? And would you like pain medication administered to keep you comfortable, even if it might hasten your death? Not exactly euthanasia, but if you need a lot of morphine to be comfortable, that might cause you to pass away faster, and that's an option you can choose ahead of time so that when you're in that moment, your family members who might not be ready to let you go will have a written indication of what your intention is. So that's the main point of the healthcare directives. The HIPAA authorization is to allow your agents to have access to your medical records, which are protected under the federal privacy laws, the HIPAA. And you need both because your advanced healthcare directives gives an agent authority to make decisions for you, but under federal law doesn't necessarily give you access to those records without an explicit authorization. So that's where they both come into play. Next important estate planning document is called a durable power of attorney. And you may hear this by various names. You might just hear power of attorney. You might have heard general power of attorney. You might hear durable power of attorney, durable general power of attorney, financial power of attorney. All of these variations mean the same thing. And here when we say durable, what that means is, durable means it lasts, right? So if you became incompetent, the power of attorney is still valid. That's what a durable power of attorney is. When you see the word general, it means generally about your assets. and not for some one specific purpose. You might have a special power of attorney that's just limited to dealing with the sale of your rental property, and while you're out of the country or away on the mainland, your spouse or friend or someone can actually sign the documents, but all they can do is that special limited power of attorney's purpose, right? Whatever specified in there. The general power of attorney, on the other hand, is for whatever things that you've authorized. That could be all of your financial assets in any way, or you can limit the scope of it to some extent. But the general power of attorney generally allows you to do anything that might need to be done. Your last will and testament, which is your will, right? You're basically what your last wills are. And this is a document that says whatever assets you own at the time of your death, what happens to them, and who can actually manage them after you've passed away. Your financial power of attorney is only valid during your life. Once you've passed away, we can't use the power of attorney to sign things for you. So at that point, it's the executor of your estate, or in modern days call it the personal representative. So the personal representative is the person who has authority to manage assets that you owned after your death. And your will can name who you nominate for that. And if we have to go to probate court, the judge will appoint that personal representative who now has legal authority to transfer assets that you owned. The classic example is if you own real estate. Let's say you had a property in your name and the deed shows you as the owner. When you pass away, if there's no joint owner, who's going to inherit it? Who can sign the deed? You can't once you're gone. The agent under power of attorney can't once you've passed away. And so we have to have legal authority to sign that deed, and the judge can appoint the personal representative who can now sign that deed legally to transfer it from your estate after you've died to the beneficiaries or the heirs, whoever's supposed to inherit it. So that's the main function of the last will and testament, appointing who can manage it and who gets your stuff. But also a key thing for young families with perhaps minor children is whom you would want to name as guardian for your minor children if you passed away, right? If you have a husband and a wife or a couple and you have minor kids, what if you both pass away together and your kids survive? Is it the husband's family or the wife's family that raised it? Maybe they fight about it, right? You folks can decide who you would want to be the guardian, who you think is the best person to take care of them. And of course, the court always has some leeway on that, but whom you nominate has strong sway in terms of deciding who gets custody of the minor kids, right? So that's a huge component as well of your will. And then a revocable trust. So these are the main components of a basic estate plan that most people have. Why would we want a revocable trust? What's the difference between a trust and a will? If I have a trust, why do I need a will? Right? These are the questions I hear a lot from people. The idea is that anything you own when you pass away in your name, if it doesn't have a beneficiary named or a joint owner, then it's subject to potentially your probate estate. Any real estate in Hawaii that doesn't have a joint owner or a beneficiary named would have to go through probate no matter the value. Even if it's virtually worthless land on the Big Island that's been run over by lava and there's no access to it, maybe it's worth $100. If you want to transfer ownership of it, you have to go through probate court no matter the value. For other assets that are not real estate, stocks, bonds, cash, corporations, LLCs, business interests, anything else that's not real estate. If the total value is over $100,000, you would go through probate court. If it's under $100,000, the person who would be appointed personal representative can bypass probate process and just say, I'm going to collect this from the bank and distribute it to who it belongs to. So that's the threshold in Hawaii for if there's no real estate involved. If it's under 100,000, we can avoid probate. But if you have more than that or any real estate, the will is not enough. It would require that you go to probate court to transfer those assets to the heirs. So how do we get out of probate court? A revocable trust. Yes?
So if like I got $250,000 in like a Vanguard and I got my partner with a beneficiary, I still need a trust?
Nope. If you have a beneficiary named, that will bypass the probate process. So Vanguard will say, who's your beneficiary? And you name your partner, your spouse, whoever, your parents, your sibling. As long as that beneficiary is surviving, they will get it by operation of law, is the term we use, without having to go through the probate court process. And so we wouldn't need that. But if they passed away before you and there's no alternate beneficiary, then it would have to go through probate court. Yeah, the biggest thing I think that is difficult in using a beneficiary designation style estate plan to avoid probate is that when you change your mind, you have to go look up every account you've ever had and make sure the beneficiaries are correct. You have to coordinate all of that mumbo jumbo mess. And if you ever open a new account, you have to remember to name beneficiary and who gets what. Some people with simple estates that really don't want or need to do even a will, right, some kind of plan, might use beneficiary designations. I don't think it's the best for some of these reasons. Sometimes people name a beneficiary and forget that's what was named on that account. When you have even a will, that whether you don't have probate or not because the assets are under 100,000, but if you have it all in the will, you can specify who gets what. When you change your mind, it's all in one place in one document to update, so we see it there. Same thing for the trust. If you might have more than 100,000 that could be subject to probate, but you say, I'm going to avoid it by using beneficiary designations, having the trust be the beneficiary, and then the trust can spell out who gets what, you have it all in one place to see who's going to get what. You can have extra benefits with the trust to protect the assets for your heirs that you wouldn't get with direct beneficiary designation. And so that's the reason that I think it's better to do that and not just rely on beneficiary designation to avoid probate in most cases. What is a trust, right? We've heard about it. We hear about trust fund babies. You know this concept vaguely, but what is it at its core? Essentially, it's defined as a property interest held by one person for the benefit of another. That's the simplest, when you boil it all down, that's what a trust is. And in more plain English, it's like a contract between people where you say, hey, I'm going to give you this asset, here's $1, you hold on to it, and in an hour from now, you can use that to buy, here's $1.50, you can use it to buy a Costco hot dog for my buddy Lane, and you're the trustee holding it for his benefit. And that is a valid, legal, binding trust, right? Even without a document. So it's basically an agreement with some instructions for someone to hold property for the benefit of another. And trusts can be revocable or irrevocable. They can be a living trust or testamentary trust. You can have a regular or a legacy, dynasty, generation skipping, right? There's these different features about trusts that people will see. And so what is the difference, right? Revocable means you can cancel it and take the assets back out of the trust. Irrevocable or irrevocable is that once you've set it up, you don't have the right to cancel the trust and take it back or amend the words of the trust. And that's a key thing there. It's about amending the words of the trust. Some of the provisions or terms or paragraphs in the trust can give you a lot of flexibility where even if it's irrevocable, you reserve the right to change who the beneficiary is at your death by specifying in your will that someone else will get it, right? As long as you build enough flexibility into it, even if it's irrevocable, you can change what the outcome is at the end of the day. Living and testamentary. A living trust means a trust you created while you're alive. A testamentary trust is a trust that is created by the terms of your last will and testament, of your will. So if you've heard of the Bernice Pauahi Bishop Estate or Kamehameha Schools, that was a will of Bernice Pauahi Bishop that said, in my will, I'm going to leave my assets for the Keiki of Hawaii, right? And so it created a charitable trust, and it was testamentary because she didn't create it while she was alive. At her death, her will created this trust. So that's a testamentary trust. And when we say regular or legacy or generation skipping, this is one that I don't like the term generation skipping because it's a little confusing and misleading. Most of you, if you heard the term generation skipping, what would you assume? If you left a trust that was generation skipping, that you wouldn't leave an inheritance for your kids and it would skip them and go to the grandkids, right? That's the assumption. Not how they're typically designed. It's actually shorthand for generation skipping transfer tax exempt trust. So there is an estate tax if you have enough assets when you pass away, the death tax, and there is also a generation skipping transfer tax. If you try to get around the death tax by leaving assets to someone 2 generations below, so that when you've given half your assets to the IRS and left half to your kid, when he dies, he doesn't have to give half and then leave a quarter to the grandkid. You could just leave the half to the grandkid. And that used to be a strategy in the 1950s. People would do that. I have a client who was 9 years old when he inherited an estate from his grandmother in 1955. And his father didn't get anything because she was using the generation skipping technique to avoid estate tax when her son died. In the 70s, put legislation into place to impose a tax if you try to keep doing things like that, to say when you die, you have the estate tax and a generation skipping transfer tax if it goes to someone 2 generations below or lower. Basically, this is a trust that can be exempt from that. So that's high level. We're going deep here, but the advantage is you can have a trust that continues on for multiple generations versus ending when you die, a regular trust, and just giving the assets outright to your children or your spouse or your heirs, and now there's no continuing protection from creditors, divorce. So the parties are the settlor, who is the person who sets up or creates the trust, the trustee who receives the assets, and the beneficiary who can benefit from the trust assets. And another name for settlor is grantor or trustor. Same thing, settlor, grantor, trustor. And when your trustee can't act as trustee anymore, the assets were held in their name. If it's real estate, you have the deed in the name of the trustee as trustee of the trust. When they pass away, it doesn't go through probate because they weren't the owner individually. It was technically the trust that owns it, and they were holding the title as trustee. And so you have a successor trustee who can step in, manage the trust assets after the trustee has passed away for the beneficiary, right? So that's the basic structure of how that would work. The settlor gives assets to the trustee, gives assets to the beneficiary, and there's your trust. What is probate, right? The earliest definition I could find of probate came from the year 1493, and it was the official proving of a will. If any of you ever took Spanish classes, there's a word probar, which means to test or to try or to prove. It comes from the Latin root of proving and probate, right? So we're basically saying we have a will. How do we know it's valid? How do we know it wasn't forged? How do we know it wasn't forced? So probate was a process to intervene to get a court to oversee the distribution of assets to make sure it was a fair process. That's what probate is for, to prove the will is valid and who's supposed to have control and deal with things. It is a court proceeding, so it is public record. And everybody can see what your will said, what you owned, and who got what. If you wanted to, you could look up the will of Jackie Kennedy Onassis, where after JFK, she married Mr. Onassis with his great wealth, and she had quite a bit that she left in her will. And because it's probate, anybody could look up that court document after the fact, and you can see what she owned and who she left things to, right? Most people would prefer to have privacy. At least most of my clients feel that way. And so that's another good reason to avoid probate, even if you're not worried about the expense of probate, cost-wise. I don't have a large, complicated estate. Nobody's going to fight about anything. The legal fees will be reasonable. The court fees are reasonable. There's still the privacy issue. And that is an advantage of using a revocable trust to avoid the probate process. Some of the terms that come up in probate, will, we've talked about that. Codicil, you might see that word. That's basically an amendment to a will. Where if it's a trust, you have an amendment. If it's a will, we don't call it an amendment. Lawyers come up with weird names for things, and so it's called a codicil, just so we can confuse the public and charge them more money or something. Testator is the person who died, who is giving their last will and testament, the person who is sharing their testamentary wishes. The decedent actually is a person who died, so usually with a will, the testator and decedent are the same person in question. A personal representative, we talked about, is like the executor, the person who's taking the will and managing, collecting all the assets, paying off the debts, and distributing the rest to the heirs. Small estate. In Hawaii, if your estate is small enough, you can actually get help from the small estates portion of the probate court, where you can usually do it yourself with the assistance of the clerk, and you don't need to hire a lawyer. And typically, if it's smaller amounts and doesn't involve real estate, you can get that generally under 100,000. So often it's one where probate wouldn't really be necessary anyway, but they have this small estates division to help with that. And the other way, if you have an estate that is not subject to probate because there is no real estate, or there's a beneficiary or joint owner, and all the other assets that don't have a beneficiary or joint owner, you add it all up and it's under 100,000, then how do we deal with it? Your personal representative can sign an affidavit, a sworn statement, that these are the facts, that a probate's not required. They take that affidavit for collection of personal property, and they can go to the bank, they can go to the brokerage firm and say, please turn it over, and they'll just turn it over to you. Unless it's contested and they're worried about someone suing or something, and then they might turn it over to the probate court, where probate isn't mandatory, but it's allowed for people who are disagreeing about who should get what.
So people in this room, everybody's 1 mil, 10 mil net worth, right? So like all that small estate stuff, just forget about that. All
Doesn't
y'all
relevant.
need to have trust, because the will, you're gonna go through probate. You're gonna be like Black Panther. He had a will.
Passed away.
I'm curious enough to know, what does Black Panther have after he has one movie? He had 6 mil. I would have thought a lot more for Black Panther.
Yeah, he needed to renegotiate that contract. Yeah, maybe it's the follow-up ones where you've established and they're like, okay, it was successful, we got to pay you more for the next one.
Yeah, unless you want your stuff aired out. Like
That, I guess, a good message there. So I'll quickly blast through this probate stuff. Generally, it can take 9 to 15 months on average for most of ours. It could be shorter, it could be longer. Sometimes it takes years and years. We've had one client that came to us after 20 years of probate was open and it wasn't finished because the family member who was supposed to be doing things and the lawyer would just keep putting it off and they never pushed it along. These are some of the reasons that can happen. Basically, if that's the case, get the personal representative kicked out or find a new lawyer to help you with the process, right? Cost, often 8 to 12 grand is a typical thing. If there's nobody fighting about stuff, it's not contested. When they are fighting about it, it can eat up the whole estate. I've seen this happen, not with us because we don't litigate. If it gets to that point, we just push it off to someone else who wants to fight. And there's cases where there's just a condo worth a few $100,000, 400,000 or 500,000, and more than half of it went to legal fees to the lawyers who are fighting about who gets what. Just totally ridiculous. Complications increase costs. Yep. So we talked about this already. This is the way it's avoided. Also in Hawaii, any motor vehicles are exempt from this probate requirement, even if it's worth more than 100,000. So you could have a brand new Lamborghini or Ferrari or whatever, worth a couple hundred grand, and everything else is less than 100 and you have no real estate, you can avoid probate and just collect it. Right? But if you have to have a probate for something because you're over, then the car can also be included in the probate process in terms of who gets what and how the judge will oversee that as well. Guardianship and Conservatorship. So what is this about? If you are alive but incapacitated, who can make your medical and physical decisions? If you're a minor or incapacitated, then a guardianship can be appointed for you. What's conservatorship? That's basically where it's about managing your finances or property. So you folks maybe heard recently the Britney Spears issue with her dad as a conservator for her assets, right? And there's the Free Britney thing. I want my money, I want to control it. She was deemed irresponsible and not able to do it, and so her dad had a conservatorship over it. Or recently, more close to home, we had Princess Kavanagh Nakoa, who had a conservatorship issue, right? And who could manage it? The lawyer or her longtime partner. And these are the issues. And whenever the court gets involved, it gets expensive, it gets cumbersome. We have to report back every penny that came in and every penny that goes out with a conservatorship, which if you have tens or hundreds of millions of dollars of estate, maybe that's worth the accounting for so that things don't go missing. But for the average person who might only have a home and a bunch of savings, maybe it's a couple million, I don't know if you want to have that court oversight if you have someone you trust anyway, like your spouse, who could step in and manage it. The trust owning your assets allows you to bypass this conservatorship proceedings. Whereas if it's in your individual name and say the financial institution does not honor your power of attorney, they may force you into conservatorship to get access to and control of those assets. And the biggest thing is the ongoing legal fees and accounting. That's where the expenses. Another type of thing that can be helpful for an incapacitated person is a supplemental needs trust. We can create a trust where this allows the person who is disabled to qualify for government benefits, Medicaid for healthcare, maybe Section 8 housing or food stamps or welfare, where if they don't have income, they're not capable of generating it, they have these needs, they would qualify for government benefits, but you leave assets to them, whether it's through your will or trust, you just give it to them, then they're disqualified and they can't get those benefits because they have these resources. We can create a trust that is designed specifically to say, we have this benefit for that person, but it's only to supplement the needs that aren't provided by government benefits, so we don't get them kicked off, but we can also enhance their lifestyle. Give them a trip to Disneyland, or let them provide for them cable TV or whatever.
Okay,
yeah.
So we had this question come up in our group. So I think kids with autism and those types of things is fairly common these days.
Becoming more, yeah.
What would you do? What would be your cookie cutter for net worth $3 million? You got 2 kids, one that's fine, that's not a drug addict, doing okay, and then you got one that can't take care of themselves. What do you see these people doing in
Yep.
that situation?
What I would normally recommend for a client like that, assuming that it's in line with their wishes, is when they pass, if they wanted to leave assets equally to each child, we'd have their trust split up, continue on for the benefit of child 1 and child 2, where the trust has a discrete share for each. So they got their equal share. But instead of having it come out of the trust, it stays in the trust. Child 1 can be trustee over his or her own share and the beneficiary. For child 2, if they have these special needs, we would have language in the trust that says we have what I call standby supplemental needs trust provisions, that if the child would be eligible for this type of benefit, then these language kicks in and they can still qualify for government benefits and the trust won't disqualify them. However, if they're not disabled or they're capable of managing their finances or not incapacitated, then it's a normal trust for them at that point, right? So that's like a toggle that can be switched on, built into the trust document. If we're concerned about them and say they're going to make bad financial decisions, they're bad with money, and I wouldn't want that child to be a trustee to manage it, to have control over it, then we can also put in the trust to say, notwithstanding the love and affection I have for child number 2, under this trust, although they're a beneficiary, they're never to serve as trustee, or maybe never to serve alone as a sole trustee. They always have to have a co-trustee. So there's different ways we can deal with it. Maybe we say that child 1 will be trustee over child 2's trust to manage it for them. If you're not sure about the siblings thing, maybe it's that you have a sibling or a nephew or niece or a best friend whom you would trust to be the trustee to manage it. And worst case scenario, we have a professional corporate trustee. You have the bank. Now there's going to be fees, and they usually charge a percentage of the trust estate to manage it, and there's ongoing costs there. But if there's nobody you can trust to do it, and certainly not that child, then there are options where you can have a professional Bank of Hawaii, First Hawaiian Bank, Central Pacific Bank. They all have their own trust departments, as well as the mainland banks. And then there are some individuals who are professional trustees who will do this kind of work. So they can manage it for them, invest it for them, decide how much to distribute to maintain their lifestyle and keep them comfortable without burning through it all by buying a Ferrari on the first day and then crashing it, right? Or whatever, without insurance. So does that sort of answer your question there?
I think a lot of times, sometimes, at least for myself, it's like, well, just tell me what you
Yeah,
on the menu.
yeah. A lot of lawyers will just not delve that deep. They say, oh, you want a trust? Great. You want it equal to your kids? Perfect. What do you want the name of the trust to be? Who do you want as a trustee? Who's going to be the successor if you die? Great, I got it. We'll see you next week and you can come sign the documents. And they'll do a cookie cutter form that's not too customized, and it'll just say, when I die, it's for my spouse, and when the spouse is gone, it'll just give it all to my kids. And they may not have even asked the question about, what about the child with autism or other severe disability? Can they manage things or whatever? Is there a rocky divorce about to happen with one of your kids and you don't want to put the assets directly in their name? It shouldn't be available, but it's riskier once they get it in their own names versus having it protected in the trust. So there's a lot of things that when you do really thorough estate planning, you'll want to get into that nitty-gritty with your attorney, give them that kind of information so that they can customize a plan that will solve for those issues. Yeah.
How often is that, in that situation, the brother or sister made the trustee versus a very expensive, faceless trustee?
In my experience with my clients, almost always, if there is a sibling, they want the sibling to manage it for them. Or sometimes it's like they've got kids and maybe there's a grandchild with an issue. So they'll say, hey, if my child dies, then I don't want that grandchild to be trustee over their own share. And in fact, I want my other child, his uncle, to be the trustee or something, right? I'd rather that than his dad, who is not my family member, right? I don't trust the in-law or something like that, right? So you'll see different scenarios. Sometimes it's, I don't trust my kid. I want my daughter-in-law to manage it because my son is just terrible with money, right? So I want her to be the trustee. Rare, but I see that sometimes too. Generally, it's usually someone in the family to keep that control close to home and to allow them to use it as they need and want. But if there is no one, I have a handful of clients where they're like, there is no family that I think would be good and I don't want this person to have that. Or even for I don't have any other kids to leave it to. I want to leave everything to charity when I'm gone. But what if I become incapacitated? Who will be the successor trustee? I'll have my bank do it. And they're going to take fees, but there's no one else I would trust with my money if I'm incompetent and to pay my bills at the care home or whatever it is. And so there are people who choose that option because they just don't have anyone close to them they can trust. So the moral of the story is, have a lot of kids and the chances that you get a good one is higher, and then you have someone that can manage it. Yeah, so we can avoid the conservatorship with a revocable trust, a durable power of attorney. It's not quite as useful as a trust, but it is also better than not having anything. And avoiding the guardianship of your person, right, when you have medical decisions to be made with an advanced healthcare directive and the HIPAA authorization. And your minor child, your will can appoint the guardian of who you would want to be the person to take custody of your minor child. But it doesn't have to be the same person who has custody to raise your child who's managing the money for them. You might say, my sister is amazing with kids. I want her to raise my children if anything happened to me, but I would never want her to manage the money for them because despite her good intentions, she would never steal it, but I think she would mismanage it and misinvest it and blow it all. So I want my brother, who's really good with that stuff, to be the trustee to manage the assets for my child. So that's possible. We'll talk about estate tax for a second here. There are now two estate taxes in Hawaii. We have the federal estate tax and the Hawaii estate tax, and they have differing exemptions. In 2010, Hawaii's estate tax law got passed effectively to bring it back in for estates larger than $3.5 million. In 2012, we coupled with the federal exemption. Federal government set it permanently at $5 million adjusted for inflation in 2012, and Hawaii says, great, we'll match that so that you have the same exemption on the federal and the state. So whatever you die with, if you're under the exemption, no death tax. But if you're over, you're going to pay a federal and a state estate tax. Then in 2017, they had Job Cuts and Tax Act. Yeah. So there was a tax act in 2017.
Made by some guy.
Made by some dude. And anyway, it doubled the estate tax exemption, which for wealthy people was a nice thing, right? Now instead of 5 million, you have 10 million adjusted for inflation. And that was the big exemption through 2025, and then it expires and goes back to the way it used to be. Hawaii didn't like that and didn't want to follow that doubling of the exemption. Maybe they didn't like the guy who promoted this law. And so we said, you know what, we're going to freeze it at the 2017 level, which adjusted for inflation from 2012 was 5.49 million. So Hawaii's exemption from estate tax is still 5.49 million, and it's projected to be that forever into the future with no inflation adjustment. The federal, although it's temporarily doubled and will get cut in half in 2026, is still adjusting for inflation. So even in 2026, this year it's over 13 million. So I expect in the next 2 years, let's say it would be 14 million by the end of 2025. Come 2026, we'll probably have somewhere around a $7 million exemption on the federal, but a 5.49 million on the state. So there's a decoupling of the exemption, which also means if you haven't updated your trust or estate plan since before 2018, your attorney probably assumed that it was the same, and whatever, a lot of the documents I've seen say, whatever the exemption is from federal estate tax, that gets put into this bucket of protecting that exemption, and anything else will go for the benefit of my spouse in a marital deduction trust, so there's no tax when I die, no matter how much I have on the death of the first spouse. But if that's how it's written, and you have assets in Hawaii, and you're over 5.49 million, you might fill up the bucket of 14 million, which would be exempt from federal tax, and the rest gets a marital deduction. But now everything between 5.49 and 14 would be taxable by Hawaii because your trust document wasn't updated after this change in law. I guess the moral of the story there is it's a good idea to every few years check in and see how the laws have changed, how your assets have changed. Does your plan still work? I know a lot of people just want to say, I want to get my estate planning done, I want to keep it simple, and I'm there. Unfortunately, the more assets you have, the more complicated it can get, which is a good problem to have. It's better than the alternative of not having the assets, right? But I know a lot of people just, I did my estate planning. It's not an event, it's a process. That would be like saying, I've been to the dentist, I don't need to go back, right? It doesn't quite work like that. That's just the idea of things change.
So with that, how would one use that to sharpshoot these things, assuming that the federal comes down to 5 million?
Okay.
All of us here will probably be much higher than that.
Great question. So what is in your estate for estate tax purposes? What do we include? Put this out there to show the exemption amounts. What's included in your estate is everything you own at the time of your death, plus things that you don't own, but you used to. If you gave away assets, but you kept too much control over it, the IRS treats it as if you didn't really give it away, and it's counted as part of your assets. Even if you filed a gift tax return and paid the gift tax for it many years ago, if you keep enough control or use over it, or the right to change who gets it when you die, that's also part of your estate. For example, if you have life insurance that insures your life, you're not the owner. Maybe your spouse is the owner, or your kid's the owner, or an irrevocable life insurance trust is the owner. If you have the right to change the beneficiary, then the IRS will tax you on the full value of the death benefit when you die as if you were the owner. So there's a lot of these things there that can add what's in your estate. But essentially, how do you move it out and how do you get rid of it? One way would be just give it, and then you might be subject to the gift tax, so we have to plan that out. A strategy that's potentially useful now, between now and 2026, when the exemption is going to get cut in half, would be to use some of that gift to move away up to $13 or $14 million of assets out of your name into an irrevocable trust that is not included in your estate. And so there have to be certain conditions on it. The cleanest is that you're not the beneficiary, right? So if it's for your kids and you're ready to give away a chunk, you could do that. Most people aren't quite. If you have a really good relationship with your spouse, you can set up an irrevocable trust that's for the benefit of your spouse, but not for you. And now you've given it away, you've used up some of your exemption from death tax. All the future appreciation in that trust is exempt from estate tax when you die because you've given it away now and it's not yours. So you can use that to reinvest in the name of this irrevocable trust. And your spouse and kids could be beneficiaries. If you ever needed or wanted assets from that trust, it can be distributed out to your spouse, and your spouse can share it with you. So there's lifetime benefits as long as you're still married, right? This is something we call a spousal lifetime access trust, or a SLAT. So that's one of the nicknames for this type of irrevocable trust. Sometimes we have clients who are serial monogamists, and they're on their third or fourth or fifth spouse. And for them, when they set up a SLAT, they might want to set it up for estate tax planning purposes, so it's for the benefit of their spouse during life so that they can get roundabout access through it, and for their kids when the spouse dies, or when they die maybe, right? With the idea that there's no death tax or gift tax upon moving these assets there because it's for the benefit of the spouse. But then what happens if they get divorced? Some lawyers who are a little more clever than I came up with the idea of a floating spouse provision, where we have this wealthy client who's married to someone, but he doesn't know how much longer he'll be married to this one because there might be another one. And the wording in the trust says, who is the spouse? It is the person that I am married to from time to time, my then spouse, right? And so as long as you stay married to me, you're the beneficiary of this trust, and as long as you keep sharing these things, we can have trust distributions by the trustee. So there's ways to put hamperings on it or stretch it out or protect yourself from future. If you're the one that has all the assets and you're marrying someone who doesn't have assets, then there's ways to take advantage of this law to minimize the gift and estate tax, but still make sure you can benefit from it in the future, even if it might be a different spouse in that role. Right? So that's more really sophisticated stuff, and that's one possibility before the exemption gets cut in half, to take advantage of it, to use one or the other or both spouses' exemptions to move assets into a trust that's for the benefit of the spouse and you. And maybe if you have equal assets, you can do the same thing, right? This is for my spouse and this is for my spouse. So either way, you're both a beneficiary of it. Now, if it's exactly reciprocal with half the assets and you set up a trust for each other, that's called a reciprocal trust, and that'll get unwound by the IRS as not valid. But if there's a significant difference, like who the beneficiaries are, what we usually do is say one is for the benefit of the spouse and kids, and the other is only for the benefit of the spouse. Now there's a significant difference in the beneficiaries. That gets it away from the reciprocal trust unwinding that the IRS will try to do, as well as if you do the timing of it, maybe 6 months between the two, maybe change who the trustee is of each one, maybe the types of assets that go in are different. One's real estate, one's a stock portfolio, something like that, where it's a little bit different. But there's all these little details we have to do to make sure it's done so that even though in theory it looks good, the IRS can't unwind it by one of these theories they've come up with, the reciprocal trust doctrine, the step transaction doctrine, all these things that they used and that they've won in court on that would be upheld if they challenged it again, right?
I have a slide in my presentation at the very end that kind of illustrates like how much money you need now, and then everything else you don't need gets put into one of these things. But then, like he's saying, you might put your business interests in that irrevocable trust because you don't need it. You don't need to live off of it.
Mm-hmm.
But what do you need now, right? So these are like conceptual things that I made this slide.
Nice.
But these are like the concepts that were like this stuff all pieces together. It's all experience, but his main role is to put these documents together, but it's your job to be the architect for why you're
what you need and when and why, and yeah. So another example, Elaine, his original question was, what do we do with these irrevocable trusts? I gave one example of the spousal lifetime access trust. For people who are older, maybe they're in their 70s or 80s, and they say, I've got enough, more than enough, I want to start moving things down to my kids. We would use an irrevocable trust that's just for the children, not for the spouse or whatever. And we have techniques on how to move that out without using your gift or estate tax exemption and get large amounts of money into the trust. Another possibility, if you're younger and successful and you might have time, maybe you have a parent still living, we might have a structure where we have a parent create a trust for you, seed it with a small amount of money, $5,000, and now they have nothing to do with it, and it's your trust, and you can be a co-trustee or the trustee and the beneficiary, and then sell your business to that trust and have no capital gains tax on it, and also have all the future appreciation happen in this trust that's out of your taxable estate, protected from creditors, and yet income tax-wise is just same as you. So there's some of these sophisticated techniques that we can structure where you can set yourself up where you can be the beneficiary of that trust versus giving it all to your spouse or to your kids, and where someone else is creating a trust for you, and we fund it not by giving your assets to the trust, which would make it taxable on your estate, but selling it for fair market value, or having the trust create a new business in the name of the trust and then give it all the opportunity for this business to have it grow outside of your taxable estate, right? So those are some of the options that we can look at on the sophisticated end. Yeah. I think I'm past my time here. There's so much to talk about. Estate tax, marital deduction, charitable deduction. There's special rules if there's a non-resident alien. If you're a permanent resident, you don't get all the same benefits. If you're not even a resident, then there's different rules that apply where he's going to find a spouse and bring him into the country.
Yeah.
Then we need to plan for that. No, but there's special provisions that have to be in your trust for it to work so you don't get socked with extra big taxes, right? Your $5 million exemption, it's only $60,000 for a non-US citizen, non-resident, right? So anything, if you have a friend who's Japanese and they buy a house in Hawaii, not realizing it, they might be subject to tax over $60,000 of value, right? It's trickier. So there's ways to structure it.
With the estate, if you have property in the mainland versus here, that's all encompassed in that, or does it get separated?
So for the federal tax, it's everything you own anywhere in the world, right? That's how the IRS is. Just like income you earn anywhere in the world, even if you're not living in the US, you get to pay the privilege of paying taxes here. For Hawaii state estate tax, if you're a Hawaii resident, we look at everything you own. And then it's depending on if another state has their state estate tax, we got to duke it out between who gets it. In some cases, both states get to tax you for the same asset, right? If you're not a Hawaii resident and you have Hawaii-based assets, then we use the ratio of your Hawaii assets to your total estate. Let's say you have $1 million home in Hawaii and your total estate is worth $10 million and you die as a resident of California. Hawaii assets are 1/10 or 10% of your total assets, so you get 10% of the total Hawaii exemption, $5.49 million. So you get only $549,000, and even though you only had $1 million, which was under the 5.49 exemption, you don't get the full exemption. You only get a ratio of that exemption that your assets bear to your total estate, and so you could end up paying estate tax even though you only had $1 million. You'd have only $549,000 of exemption. You've got $450,000 taxable. There's $50,000, $60,000 in tax there, right? It gets complicated when you're talking about multi-state and you have to take all those things into consideration. And does the other state have assets or exemption? Oregon state has only a $1 million exemption. Washington state is about $2.2 million. California and Nevada don't have a state estate tax, right? So a lot of states don't, some states do, it just depends. Some states have an inheritance tax, which is a little bit different from estate, because we're not taxing the assets you own at your death as your estate, we're taxing the receipt of it by the heir who's inheriting it, which is essentially the same thing, but technically slightly different and can have different outcomes. You might have an inheritance tax and an estate tax, right? The answer is you'll probably need to talk to an attorney about your specific situation to figure out what the deal is and how to structure it and try to get away from it. If you're a Hawaii resident, they're like, great, you get the privilege of living here, you get the privilege of paying tax here, right?
Or get it out of your state.
Or get it out of your estate. Yeah.
That's the takeaway. Get out of your state.
Yeah. Either way.
Yeah.
So, yeah, exclusions from gift tax and estate tax, right? You say, well, what if I just gave it all away the day before I died, then I don't have a death tax? They'll sock you with the gift tax. And same thing with the generation skipping transfer tax if you try to leave it multiple generations down. But we can create a trust that is exempt from estate tax, exempt from generation skipping transfer tax, and apply that $5 or $13 million exemption and get assets in there. And all the future growth happens where there's no transfer tax. Again, you can distribute to the kids, grandkids, great-grandkids, great-grandkids, no death tax ever on any of those assets, no matter how big it grows, even if you grew it to $1 billion during your life. And this is where the wealthiest of wealthy people structure these kinds of things to essentially have dynastic wealth. The dynasty goes on. Yeah, that's the generation skipping trust, dynasty trust that we're talking about. I guess the slides, I hit kind of the main points I wanted to for you folks. We just don't want that outcome where you pass, you leave assets to your children, they die, it goes to the spouse, gets remarried to someone maybe from another country, and then your kids get left, your grandkids get left out of the inheritance, or whatever, your kids, because your spouse ends up remarrying when you die. Those are the ways that we often see family assets diverted unintentionally. One quick story, we had a local family here, local Japanese couple lived in Manoa. They had their home, they weren't super wealthy, but they owned their home, and they only had one son, and they knew they wanted to leave it to him. And to make things easy, they just said, you know what, we'll put it in your name so we don't have to go through probate when we die. So they transferred the home into their son's name. He was married. He went to a local college and met a girl from out of the country. She was from Germany, and they got married. And they had a good relationship. There was no divorce. There was no problem there. They loved their daughter-in-law. Everything was good. He was in his 30s with his daughter. Parents were in their 70s. And the son and his wife got into a terrible car accident. True story. They both died. But the son died first, and then the wife died. So what happened to the house? When the son died, he didn't have a will. Who was entitled to his assets? His wife. She got everything. So for the few minutes or hours that she lived longer than him, she was entitled to her in-laws' house where they all lived together. And then she died shortly after that. When she died, she didn't have a husband. He was already dead. She didn't have kids. They didn't have children. Who would get it? Her parents. So her parents in Germany inherited this house in Hawaii. When they got the news from the lawyer that they'd inherited a house in Hawaii from their daughter, they said, we don't need the house in Hawaii, let's sell it and take the money. Sold the house, and the local couple were homeless in their old age, and the German couple got the money. True story. But it wasn't what they thought would happen, but that's what can happen when you try to keep it simple and just say, I'm just gonna sign over the deed, pay $250 to the lawyer, and now I don't own it, and my son has it, and everything's hunky-dory, right? All these risk factors can come up, and that's the benefit of trusts to avoid that problem, right? Even if they had given it away and it wasn't theirs, if it was in trust for their son, they could say if he dies, then his wife can live in it and use it, but she can't sell it or give it to anyone else, or if she gets remarried. Or they could say she has 2 years to keep living there and get on her feet and then move on, and then it goes to us or whoever else we dictate, right, at that point. So that could have been avoided with more careful planning. I don't know, that's a sour note to end on, yeah? So, yeah. Anything else to cover? With whom? Nope. I am not part of that group. Yeah. A quick story that might be a little more levity to the conversation. When my father was practicing, he had First Hawaiian Bank call him up and say, hey, we have a client here, he has his trust, he's trying to open his trust bank account, and I'm not sure, I think there might be some problem with it. So the bank trust officer said, would you mind taking a look at it? We'll have him hire you to review his trust. So the client came in and asked my dad to review it, and when he looked at it, he said, I quote, my dad said, this trust was all hamajang. What was wrong? He said, it didn't make sense. There were paragraphs that ended halfway through a sentence and there was like no finishing of the sentence, right, in the middle of the trust document. It was just like, there was so many problems with it, things that just were not good legal work, right? And so he asked the guy, so how did you get this trust? Did you find a form somewhere, or did you write it, or what you're doing? Where'd you get this? And the client, this was in the early 2005 range, right? He says, somebody told me I needed a trust, so I went to the yellow pages and I looked for trust lawyers. And I called the first lawyer and asked him, how much is a trust? And he said it was going to cost $3,000. And I called up another lawyer and asked him how much is a trust, and he said it was going to be $10,000. And I called up another lawyer and he said it was $950. So I went with the $950 trust. And I guess the moral of the story is that a trust, at least in Hilo in 2000, might run between $950 and $10,000, and you get what you pay for. No, that's a humorous aside there, but in reality, it'll really just depend. Typically around $5,000 is what a revocable trust might cost for a simple package with a will and a power of attorney, healthcare directives, and deed to put property in the trust. We get sophisticated planning. It can run 20, 30 grand for stuff that might save you millions in taxes or creditor protection. We have some clients where their plan is running about 100 grand, but we're expecting to save 20 plus million dollars in taxes. They have, I think, over 30 properties, right, in their portfolio. So the range is broad, but it just depends on what you need, what you want to do, how much protection you want to get. And there's like the basic get a revocable trust in place, which is less expensive, to the more sophisticated creditor protection, estate tax protection, and that's going to be a little pricier. Yeah.
Is there like a maintenance every year? I pay up this, set up my estate, my trust, and then
going on. It depends on what lawyer you're working with and how they structure it. And yes, in a sense, right? We can structure it that way where you get to call in, ask questions, update it, do meetings, see things. I recommend doing it that way. Of course, it's always what you'll negotiate with the lawyer you're working with and how you work that out. Some people say, I got it set up, I don't really want to do this thing, I'm not going to do this maintenance thing, and it might end up costing more if they do have problems or changes in the future. I think it's always a good idea to get on a plan where you're just like you would always just keep going in to see your dentist regularly and just know that it's set up and it's covered, and especially if you get a flat rate that's reasonable and their billable hours can rack up if you're not on it, then I think it's well worth doing just to have that peace of mind to know when things change, which they will. Something's going to change, whether it's the law, your family situation, your finances. We want to be able to incorporate that into keeping you updated and aware and whatnot.
I think everybody here is teeter-tottering on have it here because your net worth's local. I think 5 million is the threshold.
Yes, and in Hawaii, 5 million's already that estate tax exemption.
You need to pony up and pay
a little bit more
20,
to
30, 40 grand for an estate that gets it out of your estate. You got your living trust. There's nothing to change on that thing really. You know.
Yeah.
I mean,
once it's set up, it's pretty much runs unless you want to change out that.
you write it not like a bonehead, so you don't have to change it all the time, right?
Right.
That's the idea. Coming from the guy who I do things, right? Trying to find the best least amount of money. Yeah, don't guys from Utah. Great entrepreneurs, but you know, sometimes
Good for their business, yep.
you have some unique things about Hawaii state and the taxes here. So it's not for you, it's more for most of us here, our spouses don't want to come to this stuff. I'm saying I'm wrong. Okay, let's get going in 5-10 minutes. Everybody, quick break.
Thank you so much.
Going through this whole transition myself, it was really hard to do it without meeting other purely passive accredited investors out there. So that's why we've created the network, which you guys can join.